Hey, Chalk and Gavel listeners, welcome back. Just a few quick notes before we get started. As usual, we'd love it if you would rate and review Chalk and Gavel on your favorite podcast platform. That'll go a long way to help us expand our reach.
In addition, if you could consider going on our Patreon for just $2 a month, you can help support us to continue delivering the education law content you know and love. We're also working on some subscriber-only bonus content, so keep an eye out for that. So that's patreon.com/chalkandgavel.
Yeah, and lastly, just a big shout out to the Education Law Association. It's a great organization that Chris and I are both members of, and they've got their annual conference in Orlando coming up November 6th through 9th. And we're both going. Chalk and Gavel is going to do a couple of live recordings from out there. We're really excited. So if you love education law content as much as we do, consider becoming a member of the Education Law Association and joining us in Orlando at the Hilton Buena Vista.
Right next to Disney Springs, too.
Yeah.
So go get some shopping done. I'm making a Christmas list already. So
There you go. Yeah, so Education Law Association, it's a great organization. We'll put the link in the show notes. All right, are you ready to get started?
let's do it. What happens when a teacher's deeply held religious beliefs clash with the district's policy to support transgender students? When are schools required to accommodate teachers' sincerely held religious beliefs? What do we think about calling people by their last names only? Cudlets? Cudlets, pay attention. Let's get started.
All right, Thomas. In this episode, we'll talk about a controversial case that rocked an Indiana school district. You'll hear about John Kluge, a high school music teacher who challenged his district's student name and pronoun policy, requiring teachers to address students by the names and pronouns listed in the district's database. And that policy allowed parents and students to self-select those names and pronouns. Kluge's refusal to follow the policy, guided by his faith, led to another legal battle over religious rights in school. Plus, there's a lot more here. This case has it all. It's a bunch of First Amendment claims, due process claims, Title VII employment claims, equal protection claims, fraud claims, you name it. This kind of looks like another one of those spaghetti cases, right, Chris?
Yep, throw it at the wall, see what sticks. This is an incredibly complicated area of law right now with the intersection of religious freedoms, free speech, protections for transgender students. This one has a little bit of everything.
Yeah, so let's get into it.
Let's dig in. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Chris, before we get started, what's our bell ringer for this week?
Sure. Yeah. So I've got an update for you on the Oklahoma directive we talked about a couple episodes ago. This is the one that required every classroom to have a Bible and for teachers to teach from the Bible as part of their instruction. So this was a directive from the state superintendent. And it happened a few days after the state Supreme Court struck down what would have been the nation's first religious charter school. I remember we commented on the interesting timing of this, right?
That's right.
But the directive told everyone in Oklahoma public schools to teach the Bible and to have it available in the classroom as an important cultural and historical document. Though, if you remember, there was very much an undercurrent of promoting the idea of America as this Christian nation and kind of promoting Christian values as well. So, according to a recent article from KGOU by Beth Wallace, at least 17 Oklahoma school districts have publicly come out and said, yeah, we're not doing that.
Really?
Yeah. So apparently a lot of these districts are citing to an Oklahoma law that says determining instruction curriculum, reading lists, and instructional materials and textbooks is up to the exclusive purview of school districts. So they're looking at this Oklahoma law and saying like, hey, state superintendent, you don't have the authority to do that. That's our choice. So we're going to follow the Oklahoma curricular standards, which haven't changed, importantly, and we're just going to keep doing what we've been doing.
And that's a pretty within the typical purview of a school board, correct? Is determining curriculum and all of that stuff for the particular district, as long as it aligns with the state standards, selecting materials to meet the state standards and objectives is up to a school district.
Right. Yeah. As long as it aligns, like you said, as long as it kind of follows what the state says or kind of the broad framework set by the state. So, the state typically will set the goals or the learning objectives, and then the districts and classrooms are kind of free to pursue those however they think is best.
So this is interesting.
Yeah. So that's what these superintendents are saying, right? They're saying like, well, you know what? You didn't actually change what the rules were. You just kind of told us what you think they mean, or, you gave us this directive. And so at least 17 of them have come back and said, publicly, we're not going to change anything. And interestingly, the article also mentioned a survey that this group sent out to 540 public districts and charter schools. And they only got responses back from 54 superintendents, so not a great response rate. But of those 54 superintendents who responded, 46 of them, so 46 out of 54, said they were not going to change anything about how they taught English or social studies, with only 2 saying that, yes, they would make a change. And then further, 36 of those 54 said that they would not provide a copy of the Bible, Constitution, Declaration of Independence, or the 10 Commandments in every classroom, with only 5 saying, yes, they would do that part of it. Now, my favorite part of that, one of the respondents in the survey, when asked that question, said, we're a one-to-one technology school, so students already have digital access to all of those documents as needed. So just Google it. So the other thing that I think is really interesting in this article is it reports on superintendents talking about kind of the concerns they had with the directive. So not only does it kind of violate the school district's authority or autonomy to kind of set their own curriculum consistent with state standards, but at least, a couple of superintendents that they were quoted as saying, like, legally, we're not sure that, 1, the state superintendent can do this, and 2, that if we followed this law, that we ourselves wouldn't now be violating the law, because there's some really profound Establishment Clause concerns here.
Yeah.
Really, really important. And also, like, Oklahoma, you talked about Oklahoma's constitution as well. So, like, there's a lot of concerns here where, like, hey, if we follow this directive, we could be incurring legal liability. So we're just not going to do it. And the state superintendent has kind of come back and said, like, oh, we're going to enforce it. But those enforcement mechanisms are completely vague right now, and no one really knows what that's going to look like. So a lot of these superintendents are just saying, like, we're not going to change anything. We're just going to kind of wait and see.
Wow. Interesting.
It is very interesting. And it really kind of shows that there's a lot of room for discretion in the law. And Jamie, you and I have kind of talked about this. Cudlitz, you and I have kind of talked about this, where the law is rarely ever black and white. It leaves a lot of room for folks to exercise their discretion to kind of decide how they're going to follow the law. Yeah. And here we've got these superintendents kind of saying, look, actually one superintendent even told his staff, don't worry about it. What we want you to worry about right now is getting ready for this new school year. Don't lose focus on that. We'll work on this on our end. You just worry about getting your classroom ready.
See, and that is somebody who knows the law, because they know where
the fault lines are, right? Like they know
where those fault lines, they know where the goalposts are, they know whose responsibility it is to provide certain directives, right? And who has the authority to provide certain directives.
Right. And they know how it's enforced, which in this case, like, it's not necessarily potentially enforceable, right? Because it was just this guidance document.
And you know what? And that's a huge thing for a leader to be able to say, like when there's something as high profile as this, right? So obviously this has gained national attention, right? And these are the kinds of things that make teachers nervous.
Oh my gosh, so much so.
And understandably so, right? And to be able as a school leader, to be able to say, don't worry about this. You're fine. Focus on what you need to focus on, and knowing and being able to say that with confidence. Right?
Because they know the law, because they know how it's enforced.
Exactly. That's so being legally literate is so important. Anyway.
Yeah. And this is a great example of how that legal literacy gets translated into practice to support schools and teachers, right?
Yeah, exactly. Mm-hmm. Exactly.
Yeah, no. So I thought this was a really good story to kind of to highlight and to give a little bit of an update on that headline splashing directive.
So I guess this answers our question from a few episodes ago. Is Oklahoma becoming the new Florida?
Hey,
well, we're talking about it as much as we used to talk about Florida. So
that's true. Yeah, no.
Anyway.
We'll see. It's who knows what's going to be in the next episode.
That's right. That's right. We don't. All right. We fly by the seat of our pants here at Chalk and Gavel. This
is meticulously planned and orchestrated.
That's right. Okay. Well, let's get into today's episode. This one is a very interesting one. It's Kluge versus Brownsburg Community Schools. Before we really get into the facts of this case, just a quick background here. Chris kind of mentioned it a little bit at the top of the episode, but the legal landscape around these religious and LGBTQ issues, including specifically the topic of today's episode, which is about a teacher's refusal to call students by their chosen names and pronouns. This is a constantly evolving legal landscape right now. We've had decisions in cases like the Kennedy case that have tilted the scales more towards individual religious freedom, which is the free exercise clause in the First Amendment. And we've got a mess of a situation with the new Title IX regulations, which were in part designed to better support and protect LGBTQ students. And we've got a ton of states where those new regulations are on hold while all of these things play out in the courts, plus a whole bunch of schools in other states where this is also on hold. We talked about that in a recent bell ringer. We've got privacy and parental rights issues that are percolating all over the country, and on and on and on. So some of the decisions have favored one side or viewpoint, and other decisions have favored another side. And some cases, like the one we're going to talk about today, they're still ongoing. So rest assured, while we can't give you definitive answers on how all of this stuff is playing out, because it's all over the place and it's still ongoing, we are going to keep talking about this stuff over and over and over again because it's relevant.
It's relevant, it's complicated, and there are just so many significant legal interests that are implicated by these things.
Yeah, exactly.
And that just makes it so hard.
Yeah, and this case tackles pretty much every single one of those legal
Which is why it's such a good case, yeah.
There's like 47 different claims.
13, let's not exaggerate.
Okay. So this case takes place in the Brownsburg Community School Corporation in Indiana. That's just northwest of Indianapolis. And in the 2017-2018 school year, Brownsburg had a district policy that a student's parents, or a healthcare provider could request that students be called by a chosen name and pronouns, and that those chosen names and pronouns would be entered into PowerSchool, which is the school district's official student database, student information system. It's a very big, robust program that tons of districts around the country use to manage their student information. This policy required teachers to use the names and the pronouns that appeared in PowerSchool. And so that's, like I said, that's the official database that the school district used. It's the official roster. So every time a teacher opens up their computer and, needs to look up information on a student or anything like that, it comes from PowerSchool. All right.
Yeah. And the nice thing about that policy is it's all centralized, right? It is in PowerSchool. Every teacher sees the exact same thing. So when they load up PowerSchool, the roster tells them the name, tells them the pronouns.
Right.
And they just run with it.
Exactly. So John Kluge was a teacher hired by the district in 2014 to serve as a music and orchestra teacher. Okay. He taught orchestra classes and he taught music theory, and he was the only teacher at the high school who taught those classes. Kluge also identifies as a Christian and a member of the Clear Note Church, which is part of the
Just run at it.
Evangel Presbytery.
Yeah.
Did I say that right?
Works for me.
Okay, great. So he was very, very involved in his church. He served as the head of the church's youth group. He was the head of a discipleship program for children, leader of a worship group. He was a member of his church's board of elders, which is sort of like the governing body of the church. So he's really involved. And it matters because according to his testimony, Mr. Kluge believed that God created mankind as either male or female, that this gender is fixed in each person from the moment of conception, and that it cannot be changed, regardless of an individual's feelings or desires. So Kluge also believed that he cannot affirm as true ideas and concepts that he deems untrue and sinful. And as a result of those principles, Kluge believes that it is sinful to promote gender dysphoria. Transgenderism, according to Kluge, is a, quote, boringly old sin that has been repented for thousands of years, unquote. And because being transgender is a sin, it's sinful for him to, quote, encourage students in transgenderism, unquote.
Huh. So I foresee a problem.
Yes, I do anticipate that there is a conflict of interest and beliefs here.
Yeah, no, I think it might be a fundamental conflict, perhaps.
Yes. And we will see that conflict play out momentarily. So the district had this policy that sort of everything began really percolating around the 2016-2017 school year. The high school faculty and staff members started having conversations about how to address transgender students. Administrators invited the faculty advisor for the Equity Alliance Club to speak at a faculty meeting, along with a guidance counselor who gave a presentation about what it means to be transgender and how teachers can encourage and support transgender students. So, the district was trying to facilitate some conversation around the topic. At one of those meetings, Kluge asked how the school will handle those who believe transgenderism is a sin or a sexual immorality.
Okay.
All right.
Yeah. So starting early, like 2016, it seems like this district is being fairly proactive.
Yeah. I mean, now that this is, a solid 8 years ago, I'm having a little trouble recalling sort of the timeline, like I know
right
during the Obama administration, there were guidelines put out for protecting transgender youth, right? Title IX interpretations, right?
They did. Yeah. Right. Because protecting students based on gender identity and sexual orientation.
Yeah.
Yep.
Yeah.
Okay.
Yeah.
So right in line, but I guess these issues hadn't become the kind of cultural wedge issues that they seem to have risen into in recent years.
Yes, exactly. Not sure exactly how the district or folks at the school in those meetings responded to Kluge's questions.
Right. I mean, you can see him kind of already engaging in some advocacy, right?
Exactly.
Which,
Yeah. And
I appreciate that he felt confident and comfortable raising those concerns with the school community.
Yeah.
That says, I think, a lot about kind of the strength of the leadership.
Yeah. And so, in furtherance of that advocacy, Kluge and a few other teachers met with the principal to discuss the subject later that year. And they presented the principal with this signed letter expressing their religious objections to transgenderism and other information supporting their position that the high school shouldn't promote transgenderism. He specifically asked that the faculty and staff not be required to refer to transgender students using their chosen names and pronouns, and that transgender students not be permitted to use the restrooms and locker rooms that aligned with the gender they identified with.
Right. And that was part of the guidance during the Obama administration, was ensuring that transgender students had access to the restrooms that aligned with their gender identity.
Yes.
Right.
Yeah. So, around that same time, this is when the district implemented the naming policy that we talked about before. It went into effect in May 2017. Okay. And it basically, like we said, required all the staff to address students by the names and pronouns that appeared in PowerSchool. And as long as students presented a letter from a parent and healthcare professional regarding the need for a change, that change went through.
So that's interesting that they needed a letter from a parent and a letter from a healthcare professional. So you kind of needed, I guess that it's not a quick, like, I'm asking to go by a different name, make the change, right? Like it seems like a lot more formal than that, like a few more hoops to jump through, right?
Right.
And I think under the new Title IX regs, if those go into effect, they've gone into effect in some places, but like, I'm pretty sure the new Title IX regs said that like requiring this kind of formal documentation, it constitutes a harm to transgender students. So I think it's just interesting that they are requiring a letter from a healthcare professional to change the policy. Because, we were talking about how this policy in many ways was kind of very potentially progressive in 2017. But here, looking back on it 8 years, it seems a little odd to require that letter from a healthcare professional.
Yeah. So in addition to that name and pronoun policy, transgender students were also permitted to use the restrooms of their choice, and they were also permitted to dress according to the gender that they identified with, with respect to various school uniforms. And so as a music and orchestra teacher, there were likely some uniforms associated with, orchestra and things like that for when they do concerts and whatever. So that's why that's relevant, right?
The black dresses, yeah.
Yeah, exactly. So the other teachers that I mentioned earlier having gone with Kluge to the principal, after this policy came out, those other teachers who initially expressed those objections ended up accepting the policy, okay? So Kluge, I suppose, would be the last man standing as far as, his objections to this policy.
Right. Because if he hadn't objected to the policy,
we wouldn't be doing this
talking
episode
about it.
Yeah, exactly. So one of the things that the assistant superintendent explained in justifying this policy, the assistant superintendent said, quote, "The high school and the BCSC leadership thought that this practice furthered two primary goals. First, the practice provided the high school faculty with a straightforward rule when addressing students. We talked about that. That is, faculty need and should only call students by the name listed in PowerSchool. And second, it afforded dignity and showed empathy toward transgender students who were considering or in the process of gender transition. Stated differently, the administration considered it important for transgender students to receive, like any other student, respect and affirmation of their preferred identity, provided they go through the required and reasonable channels of receiving and providing proof of parental permission and a healthcare professional's approval." Unquote.
Okay.
Yeah. So, we all know where this is going, right? So Kluge was not happy. He told the high school principal that he would not follow the policy, and that was due to his religious beliefs, all right? According to Kluge, his religion taught that sex was an immutable characteristic and presenting as a gender other than the biological sex assigned at birth was false, and he couldn't encourage that belief or engage in that lie.
Right. So he tells the school administrators,
I'm not doing this, and here's why. Yep.
Yeah. Okay.
Yeah. And so after that, the principal, Kluge, and the superintendent had a meeting. And at the meeting, the school essentially gave Kluge three options: comply with the policy, resign, or be suspended pending termination.
Wow.
Yep.
Okay. They're not messing around.
Nope. Here are your three options. And Kluge refuses the first two, so he was automatically assigned the third option, which was a suspension pending termination.
Okay. And this is all, so the policy went live in May of 2017. So this is all like kind of the summer before the start of the 17-18 school year.
Yeah.
Okay.
So during that suspension, Kluge met again with the principal and the superintendent, and he requested the ability to talk directly with students about their eternal destination.
Wait. So he wants to
Now he wants to
evangelize. Yeah, right? Like he wants to be like, hey, based on your choices, here's where you might end up after you die.
Yeah.
Based on my beliefs about, okay, so now that seems problematic.
I mean, yes.
Yeah, well, because there's a difference between I want to promote my beliefs and I want to be true to my beliefs, right? And I think that that statement right there crosses that line.
Exactly. So, yeah, obviously the superintendent said, no, you can't do that.
Yeah.
Okay. So that was DOA, that request. So at the end of July, there's another meeting, this time with the superintendent, the district's HR manager, and Kluge. And at that meeting, Kluge proposes that he be permitted to address the students by their last names only, like the same way that, coaches often do, right? So he was asking for this last names only accommodation.
Okay.
And at this point, the administration says, you know what? Okay.
Yeah, let's give it a try.
We'll agree to allow you to have this accommodation. They write up this document, and the document says the following. You, Kluge, are directed to recognize and treat students in a manner using the identity indicated in Power School. This directive is based on the status of a current court decision, which is applicable to Indiana. And it also says, we, the administration, agree that John Kluge may use last name only to address students. Kluge is also directed not to attempt to counsel or advise students on his or her lifestyle choices.
Glad they put that in there based on last comment.
Yes.
Yeah.
Because you know what? Honestly, without him having said what he said about talking to students about their eternal destination, I wouldn't have been surprised if that little directive would have been left out of this letter, because who would have thought he would have done something like that?
Right.
But whatever, it is what it is. He made that statement. They threw this into the document, and now that piece is covered. Lastly, it also said that another teacher would be responsible for distributing the uniforms to students. Okay.
Oh, right. Because if you've got a
band
performance,
concert,
okay. And the uniforms are based on gender.
Exactly. So I guess the district did not want him to feel obligated to give a transgender student a uniform that didn't align with Kluge's beliefs, right?
Sure.
So Kluge said that he understood the policy to mean that he would refer to all students, not just transgender students, by their last names only, and not use the kinds of honorifics like Mr. or Miss to refer to any student. And if any students were to directly ask why he used last names only, he would simply respond by saying that he views the orchestra class like a sports team and that he was trying to foster a sense of community. He also understood that he would not be required to distribute gender-specific orchestra uniforms to students, so it kind of sounds like he understood, like he was on the same page with the administration.
Right, yeah, and you can see kind of the balance being struck here, right? Like the administration keeps the policy.
Yep.
The policy is in full force and effect, but we've tried to figure out a way to ensure that Kluge is still respecting students and, not making anyone feel alienated by misnaming or misgendering them, while still also kind of making sure that he doesn't have to, from his perspective, kind of like contribute to what he sees as a lie.
Yes.
Right. And so this kind of does seem to be if it works, right?
A win-win.
A win-win. Exactly.
Yes. So we're done, right? Everybody's happy?
Yeah, of course, right? But the thing that I think is really interesting about this is I don't know about this lie to students, right? Like he says, and if he gets asked about the last name policy, he's just going to say oh, hey, this is like a sports team, so I'm just going to use your last names. I kind of don't like that.
Right.
Right? I almost think it would be better just to be upfront and honest about the balance of values here.
That's kind of where this ends up going, right? I kind of, when I was reading through this, I was kind of thinking okay, if he is claiming that this is what he understands of the policy of his accommodation, right? And he is basically saying, I'm going to try to leave my religion out of the conversation and simply say, this is why I'm calling everybody by their last names. That's sort of where this case ends up going is what would happen if he did say, I don't agree with this because of my religious beliefs? That would in turn potentially make the situation uncomfortable in his classes.
Yeah. But to kind of counter that though, everyone in high school knows everything, right?
Yeah.
The gossip mill is,
of course.
Right? So if he's, he's been teaching there for years, 3 years, I think at this point. So if he stops, if he, changes something, the students are going to be wait a second, this policy went into effect. he's now no longer using first names, I think we might be able to connect the dots, right? Like,
of course. And it sounds like they do, right?
Right.
Like, and
Right.
the other thing is the guy is so involved in his religious community. It's not like,
that's probably not a secret, right?
yeah, it's not like something that he just practices, when he is alone or not around other people or whatever. It sounds like he is incredibly involved and very active in the community. And so, I'm sure there are plenty of students and families at that school who know him outside of
Right.
school, right?
Yeah. And so I see your point that like, if he kind of introduced this and said like, hey, based on my religious beliefs, here's what I'm going to do to kind of follow this policy, like, that could result in folks feeling alienated or not recognized, or, it could also bring his religious beliefs into the classroom in ways that could, raise these questions about proselytizing and things like that.
Right.
Another way to do that, though, would be to kind of say like, and here is why I'm doing that. It's because I want to respect you all and do so in a way that balances, like your right to be recognized with my own religious beliefs and values. And so that way it kind of affirms the interests of transgender students while also kind of like recognizing his interests as well. So like, I guess like maybe it's just my hang up about like lying to students.
Oh, yeah.
Because just like everything that kind of gets filled in is almost worse than just being honest. Right.
Well, exactly. Because like you said, like there's no secrets and kids know when you're being disingenuous. Right. And so essentially that's what ended up happening here. Now there's a lot of, just to kind of streamline this a bit, what ended up happening the next year was there was a lot of concern being raised about how Kluge was addressing students in class. Now this was contended. Okay. So, for example, a lot of students said that Kluge wasn't being consistent in how he referred to students. And sometimes he would use Mr. or Miss and other times not. Sometimes he would he would slip up and use first names, like there were a lot of claims of that. Although at the same time, there were other students and other folks who essentially came to Kluge's defense and said, we never witnessed any of that, right? So there were a number of folks complaining about Kluge's inability to manage this accommodation appropriately. For example, according to the school's Equity Alliance Club advisor, students in Mr. Kluge's class said that they found not being called by their first names to be insulting and disrespectful. Transgender students felt strongly that they wanted others to acknowledge their corrected names, and Mr. Kluge's refusal to do so hurt them. These students also felt like it was their presence that caused Mr. Kluge's behavior, which made them feel isolated and targeted.
Yeah. Right, which goes back to kind of what we were just talking about with this, like, there are no secrets, right? Like,
yes.
They're reading between the lines here. And yeah, I can see like how just using last names would be interpreted as being disrespectful, right? Like,
I'm also very interested, though, in if any of these students might have been on an athletic team where the coach called everybody by their last names, and if they felt the same way about that.
Yeah, I think context matters though, right? Like, well, obviously context always matters. This is chalk and gavel.
Yeah.
But yeah.
Yeah. So, but it's hard to know a lot of these things, right? So another situation, one of the students in the orchestra class, their name was Aiden. Aiden testified that after coming out as transgender, quote, being addressed and recognized as Aiden was critical to helping alleviate his gender dysphoria, unquote, and his, quote, emotional and mental health significantly improved once his family and friends began to recognize him as who he is, unquote. Aiden went on to say that, quote, Mr. Kluge's behavior made me feel alienated, upset, and dehumanized. It made me dread going to orchestra class each day, and I felt uncomfortable every time I had to talk to him one-on-one. In addition, Mr. Kluge's behavior was noticeable to other students in class. At one point, my stand partner asked me why Mr. Kluge wouldn't just say my name. I felt forced to tell him that it was because I'm transgender. By the end of the first semester in December of 2017, I told my mother that I did not want to continue taking orchestra during my sophomore year. Okay. So, that was some of the testimony on one side about how students were experiencing being in Kluge's class.
Yeah. And that's heartbreaking, right? Like,
yeah,
that student experienced that. Because, I mean, for me, music, being in band was such a huge part of my high school experience.
Yeah, for so many kids, transgender, non-transgender, this doesn't matter. I'm going to get on my arts high horse.
Do it
here for a second. Like, the arts in school are so, so important. I mean, I am beyond passionate about having a robust arts program in schools. And it irritates me every time I hear that, well, we're just going to cut the arts because, all this other stuff is so much more important, which I think is complete BS. Because for so many students, they're never going to feel successful in math, or they're never going to feel that. That's not to say that they're not capable of that, but success is, every kid has different interests and passions and strengths and all of that stuff. And limiting what schools offer to what some people view are the most important subjects potentially puts a whole lot of students in a position where they're never going to feel comfortable or understand what success feels like. And the arts are a place for so many students to find their strengths, their passions, to find acceptance.
And find a place where they belong, right?
Exactly. So I'm not going to dwell on that too much, but yeah, for a student who might love music and love orchestra to feel not accepted.
Right. It's not like they can go to a different orchestra class, right?
Because he's
Kluge is the only one.
Exactly. So, but in Kluge's defense, there was another side to that story. Okay. There were a lot of students that submitted declarations that they never heard Kluge deviate from the accommodation that he agreed to. They declared that they never saw him treat transgender students differently. There was a woman who gave private music lessons during the school day who testified that she never witnessed Kluge deviate from the accommodation. And she also testified that she didn't think that the accommodation itself was common knowledge amongst students. So
I wonder how well she knew high school students.
Exactly. But that goes back to, my point here is there's a lot going on between the lines here that we that we don't know.
But so whether or not Kluge is consistent with the accommodation, I think the bigger issue is just the accommodation itself seems to be the problem, right?
Yeah.
And so obviously his inconsistency, if he's not doing this consistently, or if he's refusing to call on transgender students or whatever it might be, that is obviously a huge problem. But there's also a huge problem with just the last name policy itself, right? Because it seems to be the last name policy itself that is also getting a lot of criticism from these students based on kind of how they're experiencing it.
Exactly. So they met a bunch of times to address these concerns that were being raised. Okay, the principal and Kluge. In January, the assistant superintendent gets involved to try to settle this a little bit better and provides a document to the entire faculty that's titled Transgender Questions.
That makes it seem like the questions have changed their gender. I think they need to retitle that document, but sorry.
So this document reiterated the district policy that staff and faculty should follow, addressing students by the names that were in Power School. And it included questions and answers like, are we allowed to use students' last name only? And the answer that the district provided was, we have agreed to this for the 2017-2018 school year, but moving forward, it is our expectation that the student will be called by the first name listed in Power School.
Ooh, okay.
So they're basically, the district is starting to take a stand here to address the accommodation and the potential confusion and gray area that accommodation essentially created.
Yeah.
Right?
And so this is another situation where we've got the school district who kind of tried out something, it didn't work, and now they're reversing course.
Clarifying, whatever,
right? We talked about this in our episode about the LGBTQ inclusive books, right?
Right. Once things start bubbling up after a policy is implemented, then the policy is either changed or reinforced or whatever. And, listen, it makes sense to be able to have the ability to do that because, as long as we're doing it for the right reasons and as long as we're making thoughtful changes, we should have policies that are responsive to the changing needs of our students and our communities, right?
Right. Absolutely. Yeah. Like, especially in this evolving context, right? Like,
yeah.
And especially like after you kind of see what the results of the policy were and whether or not those align with your goals, like, yeah, absolutely want people to be able to revisit those things.
Yeah. Yeah. So the letter went on to share with faculty and staff the feedback and the information that had been received from transgender students since that policy was implemented. And they said that they appreciated the teachers who were accepting and supporting of them, although they felt dehumanized by teachers they perceived as not being accepting or who continued to use the wrong pronouns or names. Non-transgender students in classrooms with transgender students have stated that they felt uncomfortable in classrooms where teachers were not accepting. For example, teachers that called students by their last name, don't use correct pronouns, don't speak to the student or acknowledge them, etc., etc.
Interesting.
So including a lot of this student feedback.
Right. And this is both students who identify as transgender as well as cisgender students.
Yes, exactly.
Yeah. So like everyone is kind of like picking up on these cues and these signals and
at least what the district
put out in this letter.
Like for all we know, the district could have received information to the contrary from students that they chose not to include in that letter. We don't know.
Sure. Well, if they get, everyone's going to experience these policies differently, but it's a question of like people who don't see it versus people who do. Like the district can kind of make a determination on who it wants to prioritize and how it wants to accomplish its mission, right?
100%. So after that document goes out, Kluge emailed the superintendent and the principal, asking if his accommodation would continue into the following school year.
Doesn't seem like it.
No. So they have a meeting with Kluge, and the district told him that he would not be able to continue using that accommodation. Okay. And guess what we have again? We have the district giving Kluge 3 choices: follow the policy, resign, or be suspended pending termination.
All right. So we're back to where we started 1 year later.
Exactly.
But hey, at least we tried something, right?
Yes. Now things get a little, at this point, Kluge sends in his resignation, and there's a little back and forth about whether or not the resignation was conditional, meaning that he could take it back if he changed his mind. Kluge thought that he would have the option to take it back. The district didn't think that that was an option that they provided him because at some point, Kluge did try to rescind the resignation with a renewed request to continue the last name only accommodation, but the district had gone ahead and processed the resignation. So Kluge asked the board to accept his resignation.
Right. So he tried to use the just kidding defense.
Yeah. Yeah. And so in June of 2018, Kluge asked the board not to accept the resignation, but the board accepted the resignation anyway. And that meant that he was done as an employee of that district. Okay. Right before I turn it over to you, because this part has gone on long enough.
This is an interesting story.
Yeah.
Because this is one of those situations where I think the district handled it really well.
It sounds like it. But there's one last little tiny interesting wrinkle. Towards the end of the year here, there is a orchestra awards ceremony. Okay, pretty typical. And at the ceremony, Kluge addressed all students by their first and last names, including the transgender students whom Mr. Kluge addressed by their chosen first names. So
interesting.
There's this awards ceremony, and he followed the district's policy. Okay. Now, his response, when questioned about why he did that, when he has been so opposed to it, his explanation was that he used those first and last names because, quote, it would have been unreasonable and conspicuous, unquote, to refer to students by last names only at a formal event.
Okay.
So he's basically saying, because this is a formal event, I am okay with or I don't want to say I'm okay with the policy, because he was not okay with the policy,
Right.
but he was willing
In this
to,
context, I'm willing to.
I'm willing to adhere by the policy.
Right. And that's really interesting, because his whole claim has been, my religious beliefs say, very specific things about sex and gender, and I think it's a lie to identify something you're not, and I don't want to participate in that lie, has been a big part of kind of his perspective. But here he is, like, there's a context in which those religious beliefs can bend to the context. And I think that that's really interesting. But good on...
There's a lot here that we don't know. Like, we need to get into his head, which we can't.
Right.
But
I appreciate that he used the transgender students' names and pronouns here, just because, to his point, that is a very formal event. It's very meaningful. And to be appropriately recognized, I think that goes a long way to affirming these students.
Yes. So anyway, he's no longer employed with the district, and he goes ahead and files a lawsuit.
Does what everyone does in a Chalk and Gavel episode, and files a lawsuit.
Exactly. So what happened?
Yeah. So just as a heads up, this case has been going on for about 5 years. And as we'll talk about,
this episode has been going on for about 5 years.
This episode will probably finish before this case does. But the case is still not over. It's still working its way through the courts. So this one's got some twists and turns. So the initial complaint has 13 claims.
Oh, boy.
So it's got a little bit of everything, something for everybody here. So we've got allegations of religious discrimination based on a failure to accommodate under Title VII. Talk more about that in a second. We've got retaliation under Title VII. We've got a hostile work environment claim. We've got retaliation claims under the First Amendment. We've got content and viewpoint discrimination, compelled speech under the First Amendment. We've got violations of his right to free exercise of religion under the First Amendment. We've also got some due process claims under the 14th Amendment, as well as an equal protection claim under the 14th Amendment. And then we've got some state law claims based on tortious intentional infliction of emotional distress, violation of the Indiana Constitution's religious liberty clause, as well as fraud.
Fraud?
Yeah, I know. We don't talk about fraud a lot.
Wow. That's a new one.
So a lot of stuff going on here, right?
Okay.
The school district gets this complaint, reads through all 13 claims, and they immediately file a motion to dismiss all of the claims. They're basically saying, we don't think Kluge gets to pass go. Even if you accept everything that Kluge is saying here as true, there's nothing here to show that we violated the law or that we're legally responsible for any harm.
Okay.
And they make this motion. To survive at this stage, Kluge has to show that his claims are facially plausible. So we've talked about motions to dismiss. Jamie, do you remember the civil rule for this?
No, I don't.
12b-6.
Oh.
It's our favorite. 12b-6 motion to dismiss.
Lawyers.
But so it's a 12b-6 motion to dismiss. And you just the bar is pretty low here. You just kind of have to prove that a court could draw the reasonable inference that the defendants acted illegally or violated Kluge's rights.
Okay.
So even with that kind of fairly low bar, the court ends up dismissing a lot of Kluge's complaints at this stage. So first off, Kluge doesn't even try to defend his equal protection claim. So that one is out the window immediately. And then the court looks next at, the rest of Kluge's claims to see if they're facially plausible, starting with his First Amendment speech claims. Now, if this sounds familiar, it should, because we just covered this in our last episode. So Kluge is arguing that the district, retaliated against him, punished him for his protected speech, that they impermissibly compelled his speech, requiring him to affirm students' gender identity, and that they engaged in viewpoint discrimination because, they punished him for his religious objections, but they didn't address or punish anybody for folks who supported the name policy, right? So that's kind of his First Amendment claims are all kind of predicated on those concerns.
All right.
The district, for its part, says all of Kluge's speech here was pursuant to his official duties as a teacher, and therefore is unprotected because it's basically the government's speech at that point. So think back to what we talked about last week. So if you're evaluating a public employee speech claim, one of the first things you have to do is you have to ask whether or not the speech was pursuant to the employee's official duties. If it's pursuant to the employee's official duties, then the government has pretty much complete control over that speech. And so here the court looks at this and says, yes, addressing students is absolutely part of the teacher's official duties.
Right.
And the court says that, while addressing students by name may not be part of the music or orchestra curriculum, it is difficult to imagine how a teacher could perform his teaching duties on any subject without a method by which to address individual students. Indeed, addressing students is necessary to communicate with them and teach them the material. How teachers relate to students is part of their jobs, and running a classroom is a core academic duty. So here, this is very clearly part of or pursuant to his official duties, like talking to students or addressing students in class.
Yes.
That seems pretty intuitive, right?
It does. It's nice to hear the court back you up on that from a sort of a legal standpoint.
Right. But at least 2 courts have come to different conclusions on the same question.
Of course.
Well, yeah, right. But these courts, they've held that the pursuant to official duty test actually doesn't apply to compelled speech, because here we're compelling this teacher to use names and pronouns. Basically, we're requiring him to speak rather than forbidding him from speaking.
Okay.
I don't know if that makes sense, because you're forbidding him from misnaming and misgendering a student, which I guess is the same thing as requiring him to properly name and gender the student. So 2 sides of the same coin, I would think. But the bigger thing here is that for those courts who don't see this as part of the official duties, they're more concerned about requiring the teacher to become kind of a mouthpiece for the school's preferred ideology, but they kind of limit the pursuant to official duties doctrine to just apply to the delivery of the curriculum, which is just so narrow and decontextualized, right?
Mm-hmm.
They don't seem to understand what goes on in a classroom. So anyway, I think the Kluge court got it right, that this is very much pursuant to Kluge's official duties and therefore is not protected speech. And the court even goes on to say that even if this was protected or not pursuant to his official duties, it's not on a matter of public concern, because we're not talking about Kluge's ability to say his perspective on gender identity issues or religion. He's free to do that, maybe not as a school employee for obvious reasons, but, he's still free to express his opinions. What we're talking about here is more about just kind of the purely private matter of addressing individuals. So that doesn't contribute, according to the court, it doesn't contribute to the broader public debate on transgender issues. Instead, it's just this purely private matter of how we address each other rather than speaking on these big private issues. So the court says, Kluge, you don't win on your First Amendment free speech claims because it was pursuant to your official duties, and it's not a matter of public concern how you address them. It's not a matter of public concern. The addressing them is not a matter of public concern.
Right. That makes perfect sense.
So far, so good. Now we got to talk about Kluge's First Amendment free exercise claim. So this is his religious claim, saying that essentially he was discriminated against because of his religious beliefs. So to establish a free exercise claim under the First Amendment, we talked about this in Kennedy, you have to identify a policy that is not neutral or generally applicable that burdens religious exercise. And so policies that incidentally burden religious exercise but are neutral and generally applicable do not violate the free exercise clause.
So on its face, it kind of sounds like option number 2.
Right. Yeah, because the law doesn't single out religion. It doesn't say anything about religion. It doesn't target religion. It doesn't disfavor religion. It applies to all teachers and all staff.
Yeah.
And it wasn't adopted with any kind of religious animus or intent to impede religion. So all of those kind of go into recognizing that this policy is neutral and generally applicable, and therefore, even if it does incidentally burden, it's not constitutionally suspect.
And it's also potentially, one could argue that it doesn't necessarily, even though it might be designed for transgender or gender nonconforming students, it sounds like the policy would also apply if you are a cisgender student who just wanted to go by a different name for one reason or another.
Right. Chris rather than Christopher.
Right.
As an example.
Or even if it would, you wanted to make a big change, and go from William to Steve, or maybe you want to be identified by your middle name instead of your first name, your given name.
Sure.
Right. Or you've got a nickname that everybody calls you. Everybody calls you Junior, right? You've been
Right.
called junior since you were born because you're named after your dad or whatever, and but you want to go by junior. It sounds like this policy would apply to any of those situations, right?
Right. Yeah. So it's generally applicable. It applies to all students and it applies to all staff members too.
Right.
So like
Yeah.
there's no exceptions here. There's no carve outs. There's
Right.
no issue about like religion being treated differently than non-religion.
Yes, exactly.
Yeah. And so all of that goes into the court kind of saying that, there's no free exercise claim here because you can't point to a non-neutral or not generally applicable law. So we're going to dismiss that claim too.
Yep. Okay.
And then the court goes on, there's 13 claims. We're not going to go through all of them. But then the court goes on to dismiss all of the remaining claims except for 2. So
Okay.
2 claims survive the motion to dismiss.
All right.
We've got our Title VII failure to accommodate claim and our Title VII religious retaliation claim.
Okay. So just as a reminder that Title VII is an employment statute.
Right. I know we have a lot of titles in education, right?
Yes.
Title IX, Title VI, Title VII. So yeah, Title VII prohibits employers from discriminating against employees on the basis of their religion. And it also requires employers to accommodate employees' sincerely held religious beliefs where they do conflict with rules of employment and where providing an accommodation would not result in, and this is the most important phrase for this case, an undue hardship.
Okay. So essentially what that means is employers have to accommodate their employees and not discriminate based on religious beliefs unless it essentially causes too many or too big of a problem for the employer.
Right. In which case, then they do not have to accommodate the religious beliefs.
Correct.
Yep. And so, that was the motion to dismiss. We've got these 2 Title VII claims that survive the motion to dismiss. So fast forward a little bit, everyone kind of engages in discovery. We do depositions. All of that fun stuff happens. And then Kluge files a motion for summary judgment on his Title VII failure to accommodate claim.
Okay.
And the school district, not wanting to be left out, files a cross motion for summary judgment on all of the remaining claims. And drum roll, please. The court grants the district's motions for summary judgment, concluding that the district did not violate Title VII when it denied Kluge's request to continue using students' last names.
Interesting.
So the trial court finds for the district or grants the district's motion to dismiss. That dismisses all of Kluge's claims, so the case is over.
But you said earlier that it's not over.
Yeah, it's not over. So Kluge appeals this to the 7th Circuit, and the 7th Circuit Court of Appeals agrees with the lower court and agrees that the school didn't violate Kluge's rights under Title VII. They affirmed the lower court's decision, so now it's over.
Oh.
Except it's not.
Oh.
I'm sorry. So while this is all going on, the United States Supreme Court decides a case about the meaning of Title VII's undue hardship standard. So when this was all working its way through, the trial court applied the old undue hardship standard. And then the Supreme Court decides this case, Groff versus DeJoy, which clarified the standard for what constitutes an undue hardship for employers under Title VII. Before Groff, an undue hardship basically required the employer to accommodate any employee's religion unless it resulted in some de minimis cost.
Mm-hmm.
So it was a very low bar.
Okay.
But after Groff, the Supreme Court said, you know what, that bar is too low. It's only an undue hardship if granting the accommodation will result in substantially increased costs in relation to the conduct of the employer's particular business. So we go from this de minimis standard to this substantial increased cost standard. So that's a much higher bar. So the 7th Circuit says, hey, the standard has now changed. We're going to vacate the lower court's decision and make you do it again with the new standard from Groff.
And when you say cost, they're not specifically talking about a monetary cost, right? They're talking about cost as far as a company's or employer's
like
mission,
efficient
its
operation,
program, its operation, all that stuff. So it's basically saying a burden, right?
Right. And that's kind of what the big thing is for this school case, right? Because schools, we don't typically think about increasing costs.
Yeah. And
for
something
school.
like this is not an increase in costs, at least directly.
Right. And yeah, because it's not necessarily, and it's weird to think about like schools as businesses and students as products, right? Like that's a really yucky metaphor. So the Seventh Circuit vacates the lower court opinion, remands it back down to the trial court to apply the Supreme Court's new standard. And so we're back at the trial court, and the parties again file 4 cross motions for summary judgment. And this is the opinion that came out in April of 2024. So this is the most recent decision in this case. It is now on appeal to the Seventh Circuit again.
Yeah.
So that's why we're saying this isn't over yet. But the trial court, applying the new standard from Groff, finds that the district didn't violate Kluge's rights under Title VII.
So they're basically saying what Kluge was asking for was going to amount to a significant enough hardship on the school or the district that basically they're not at fault for not accommodating his religious beliefs.
Right. Yeah, they didn't have to accommodate because as an accommodation, if they had been required to do it, it would result in an undue hardship.
Yeah. Okay.
Exactly.
Okay.
Yeah. The court explains that, when we're analyzing undue hardship, we have to do that in the context of the employer's particular business, right? That's what the Supreme Court told us to do.
Mm-hmm.
And for the district, their mission, as they say it themselves, is to foster a supportive learning environment for all students. And that is critical.
Yeah.
Because we're going to evaluate the accommodation's impact on that mission.
Yep.
And Jamie, to your point, like if it's substantial enough of an impact on that mission, then we don't have to grant that accommodation. And so the court is looking to whether or not, this last name's only accommodation undermines the district's legitimate mission to create a substantial.
The district's mission to create an inclusive and accepting sort of environment.
Right. And whether that creates a substantially increased cost and hence an undue hardship. Yeah, exactly. Yeah. See, we got there together. Right. And so, based on the evidence, it's pretty clear here that the last name only accommodation is really substantially undermining the district's mission to create a supportive learning environment for all students. Right. Mm-hmm. We've got all of these different students who have said, I didn't feel welcomed. I didn't feel valued. Both from transgender students and cisgender students, right?
Right.
They're saying that, the last name only policy alienated students. We've got testimony from students who say hey, I can't be in this class anymore. We've got all of these issues percolating in the school. And while some students might not be experiencing that, and there might be a question about how widespread it is, the district, had a pretty substantial documentary record to demonstrate how much this policy impacted their ability to create a inclusive environment for all students. So because they had the receipts, they were able to back up the undue hardship that the last name policy resulted in, and therefore they didn't have to continue it.
Right. Yep. That makes perfect sense in light of all the facts of this case.
It does. And I think that that's kind of the end of the story for now, right?
For now.
Because this is on appeal, so we'll see what happens next. But I think that idea of keeping the receipts, and I know we've talked about that a lot, that's so important here because the district, that's what wins the day for the district, because they're able to kind of not just say, hey, this accommodation would contradict or fundamentally undermine our goals. They're able to point to evidence saying, look, here's how it did undermine our goals. And we tried. We tried to accommodate Kluge's religious beliefs, but we couldn't because of our fundamental mission.
It was causing too many problems. Yeah.
Yeah, exactly. And so that's why we joked about them ending up in the same spot a year later with the 3 options, right? Follow the policy, resign, or get fired. But that year
was
really
critical.
Kind of, it was critical. Yeah. Because it allowed them to prove that they were trying to accommodate Kluge's religious beliefs. And when it became clear that they couldn't do it anymore, now they were in a legally justifiable spot to end his employment relationship.
Yes. Well, we're going to have to wait and see what the Seventh Circuit Court of Appeals decides to do in this case. This was I think the appeal was filed in June or something like that. So relatively recently.
Relatively recently, yeah. So I had no idea when they'll come out with a decision, but actually, if this gets overturned, it would be our first case that got overturned that we've covered, because it's not the first one to get reviewed, but all the other ones that have gotten reviewed have been affirmed. So hopefully we can
keep our
track record. Our track record. Right?
All right. Well, that's an interesting one with, very important and timely, relevant implications for teachers and school administrators and districts. But yeah, like this, we've talked about how this is because this landscape is constantly evolving and there's so much gray area, being aware and being legally literate is going to be very helpful for schools and districts and teachers, right? To best navigate and function within the bounds of the law and carry out your educational mission.
Exactly. Yeah.
So,
because the worst thing that can happen in these situations is knee-jerk reactions that then just kind of lead to a bigger fight.
Right. Because they fall outside of the bounds of the law. Right? Yeah. All right. Well, good stuff. We'll keep you posted on how this one plays out. And if you're still listening, you can hear Thomas over here tell you about the homework.
See, it doesn't work as well for me because Thomas is actually a first name. Right? But your homework is to like, rate, and review Chalk and Gavel wherever you get your podcasts. You can check us out at chalkandgavel.com or at Chalk and Gavel on social media. If you go to our website, chalkandgavel.com, you'll be able to find our teaching guide. So it has all the cases that you can find there that we've covered, what episodes, what topic we've covered. So if you're thinking about teaching school law or doing professional development, whatever it might be, or if you're just interested to hear more about topics we covered today, you can find more information about other episodes related to those on our teaching guide. Check out our Patreon, patreon.com/chalkandgavel. We would absolutely love your support. That means absolutely so much to us, and it really does help us make sure that we can keep doing this and keep sustaining this podcast that Jamie and I love to do so much.
That's right. All right, Chalk and Gavel listeners, that's it for today. Until next time, have a wonderful day.